All right, it is 10 o'clock on the dot. Good morning. I hope that everyone is doing well. It's so nice to see so many of you interested in hearing about what's going on in the Right to Know Law and Sunshine Act. We are having an internally exciting week at the Office of Open Records. We just moved offices. You will learn a little bit more about that. And we are going to talk about a lot of things. So the way we've done it this year, in case you are more interested in one topic or the other. From 10 to 11, we're going to talk about what's been going on with the Right to Know law. And then at 11 to 12, we are going to do a basic training in the Sunshine Act, where there has been at least one significant development in recent weeks, actually. So we hope that this is helpful, and feel free to put questions in the chat, and we will try to answer questions at the end as we have time. But we will have to move at 11 to the next presentation. With that, I will hand it over to Nathan and Kyle.
Good morning, everybody. I just want to thank you all again, like Liz said, for joining us. It's always a great opportunity to present to you just an update on what's going on, as well as to give some tips and guidance on how we can all navigate things that are going on around the Right to Know law and OOR world. Well, my name is Nathan Byerly. I'm the Deputy Director here at the OOR, and I'm going to be joined by Kyle Applegate. He's the Chief Counsel. He may jump in from time to time to offer additional insights, but we'll definitely be talking about some of the updates in the law that we've seen. What we want to cover today is just the latest developments that we've seen in the Right to Know law, some of the things that we're facing here at the OOR, and I would ask for your patience because, as the next slide is going to show, we are in a new mailing address. And as Liz mentioned, we have moved our physical location. We are now at 555 Walnut Street, Suite 605 in Harrisburg. It's just a few blocks over from where we were previously, but our phone number remains the same. Our web page remains the same. The portal remains the same. The only thing that has changed is that actual mailing address. Part of that move has been delayed a little bit, and we're still working. We don't have our training room done, so we're doing this kind of piecemeal, so to speak. So I would ask for your patience. We have some people answering questions in the chat section, which you can, as the earlier slide said, you can ask those questions as we go along in the chat section. We had someone call in sick today to complicate things. So we're kind of working through this. So if we have any hiccups during it, we just ask for your patience as we work through that. Going back to the address and the change of address, I would just alert everybody to make sure that your forms and web pages that have our old address are updated and that they contain our new address. Double check any pre-filled addresses that you may have, address forms or software, apps, templates, anything that you may use to train employees or the public in interacting with your agency that has that mailing address. Website posting, some of these things can slip by and be missed, and we just wanted to remind you to do all of that, as we want to make the appeal process and the right to know process in general as easy and smooth as possible. Moving on to what we're going to be talking about today. Just as a roadmap for where we're going to go, we're going to talk about the appeal numbers, what we're facing here at the OOR. Just as a spoiler, we're facing a huge spike, especially in the past couple months. I want to talk about why that matters, some practice tips that will help us help you and help you help us. Part of what's driving this is AI, artificial intelligence. We're going to chat a little bit about that, as well as discuss some tips. And then, like I said, Kyle's going to go over this past year's case law update with cases that came down from the Commonwealth Court and from the Pennsylvania Supreme Court. So moving on to talk about our annual appeal numbers. Like I said, we are seeing, and you can see the general increase. I've been at the office since almost the beginning in 2009, and it seems like it is a recurrent theme that numbers are increasing. Appeals keep going up, and they keep going up. And we talk about how surprised we are, it seems, every year that the numbers have increased. It is not let me put it this way. In just chatting yesterday, I haven't looked at what the numbers are today. There was the possibility we could hit 4,000 appeals for this year. We have seen a significant spike in the last couple months. And when you put that in context, in 2019, we had 1,155 appeals for the entire year. And now we're pushing 4,000. And the next question that people ask is what's driving this? Why this increase, especially so drastically this year, and especially in the past couple months? And we're trying to get a handle on that ourselves. We don't know. Typically, in the past years, there's been an event, say the election, that would cause it. There may be disputes within like school districts over a certain issue or something, and that may drive it. There may be research projects being done by certain political, commercial, or research entities to collect information and data that may drive some of the appeals. Inmate appeals in the past have driven some of the numbers, but there's no one theme that we can point to, and it's kind of exemplified in a conversation I had with one of our administrative staff a couple weeks ago. There's 20 some appeals that had just been filed, and she said to me, they're all different requesters, they're different issues, there's no common theme. And that kind of sums it up, is we're trying to get a handle on that. Which brings me to the next question that we look at, is why the numbers are important. Why, you talk about these numbers, our staffing's not increasing as quickly as the cases are over the years. We're very thankful for the increases we've gotten. We're going to be adding a new appeals officer. The law hasn't changed, so we got 30 calendar day statutory deadline to issue a final determination. And I understand there's situations where you can, and we do, work with requesters to get extensions, and we can do rolling production of documents in certain cases. But generally speaking, we have 30 calendar days to issue most of these appeals. And as soon as that appeals officer gets the appeal, that clock starts running. So you're talking about our appeals officers juggling different cases. And I want to highlight that agencies and requesters can make the process much more efficient. You all can help us work through this quicker. So what are some of the practice tips that we can do, or that you can do? I mean, this is a mutual thing. We're in here together facing this spike. What are some things that you can do as a party before the Office of Open Records to help us help you? And the first is submit a well-organized and concise argument. And just because you can get generative AI or chat GPT to spit out a 100-page brief talking about all these reasons the record should be public as a requester, doesn't mean you should use it. Try to keep it as short as you can. Get to the point, make your point, get in and get out, so to speak. Attorneys, if you're a solicitor, I know we are notorious for wanting to go on in our legal arguments, but if you can make an argument in 10 pages, don't make it 25 pages. If you can do it in 5 pages, do it in 5 pages. Organization is also important in that. It can be easy to fall into zigzagging with arguments, and it takes more time for the appeals officer to go through that and link the arguments together. So be organized, be concise. Same thought process on the affidavit and attestations. Submit a thorough, well-organized, concise, non-conclusory. Make sure you're not just being conclusory in your statements, in your attestation and affidavit, so you don't present those in a concise and organized way. I'm not going to go into detail on what that may entail. I would encourage you to watch the presentation that we have on evidence and review our PowerPoint that we have on presenting evidence to the OOR. We provide a very, in my estimation, good detailed explanation for how to develop an attestation and affidavit in a concise way and in an organized way. But I will highlight one of the things that I encourage, to the extent that it's requesters that use attestation or affidavits, but more agency counsel and solicitors, is use the facts from your brief or your legal argument that you submit to the Office of Open Records as the foundation for your attestation and affidavit. It's not even a half bad idea to copy and paste the facts that you have within your legal argument, drag them over to your affidavit, and then have your person that's affirming or swearing to that take a look at that and confirm that that's true, and then attest to that, because then you've got the link there between your legal argument and your affidavit and your evidence, and that can go a long way in establishing the case that you want to make for why you think a record should be withheld if you're the agency, and on the flip side, why you think it should be released if you're the requester. Be proactive in this as well, and try to take a step back and ask yourself what you would need to resolve the appeal if you were the appeals officer. What would you want to know? What legal argument would you need? What facts would you need? And you may say, well, why is that important? Because that will cut down on the number of times the appeals officer will need to come back to you to ask follow-up questions. And the appeals officers don't come to you asking follow-up questions just to be difficult. With the cases we're seeing, they don't have time just to ask these questions to be difficult. These are legitimate questions that they have that they want to get the answers to so that they can create a solid record in the event that the case should go up to the court. Because one of the things that we are responsible for as the Office of Open Records is creating a record that will be sufficient if it should go to the court, that the court can look at it and be able to determine and decipher what happened in that appeal. And then the court can make a decision as to whether or not the Office of Open Records reached the right decision. What can happen if we don't get the record that we need is it gets remanded back to us, and then we all need to basically go through the process again and have us collect that information. And the questions that I typically encourage people to ask yourself as you're developing your affidavits or your legal arguments is just basically the basic why, what, when, where, how. Ask those questions, work through those questions, because those are the type of questions that the appeals officer is going to come and ask you when you have that appeal, when they're trying to work through that file. The other tip I have, and we're gonna quickly transition to talking about this: avoid the use of generative AI. I'm going to say this probably several times here, and you'll see why here in the next few minutes. Avoid using it on any type of basis is my recommendation. So, moving on to something that we've seen, the artificial intelligence issue at the Office of Open Records. We mentioned it, I believe, briefly last year at the annual training when we were talking about automation and we were talking about anonymity and anonymous requests. But in the last year, we have seen the use of AI literally explode. Most of the appeals that we get now have some form of generative AI within them, and it just becomes increasingly more and more used. I literally every day. I mean, it sounds dramatic to say that, but it is really the case where the use of AI is really taking off. AI means different things to different people. So I wanted to really, in the importance of getting definitions down, narrow it to what we're talking about today. For the discussion today, I'm not talking about, and we're not talking about automation, like using AI to generate a lot of requests to a lot of agencies in a short amount of time. I'm not talking about the grammar check or editing process, hey, make this sound better or proofread this paragraph. That is AI. That's not what I'm talking about today. And I'm not talking about like AI is getting built into everything now. So I'm not talking about the AI that's built into apps and software like Word, Excel. The legal research platforms like Westlaw and LexisNexis are using it more and more. That's not what I'm talking about. What I'm talking about is generative AI. So ChatGPT, Grok, Google, Gemini, for example. And moving on to what the definition of it is, if you're not familiar with it, is generative AI is a type of AI that is creating new content from existing data. So it's going out there collecting from a number of different resources, a whole bunch of information, and then it creates new content out of that. So as the next slide shows, what that looks like with respect to the right to know law process is people will use AI to generate right to know requests. They will use it to generate appeals. They will use it to generate their legal arguments and their briefs. So they'll say to Chat GPT, they'll give specifics, but they'll say, write me a brief, and the Chat GPT will write them a brief. Petitions for reconsideration is another use that we have seen it come up quite frequently. Our current position on this, it's not advisable to use generative AI for any right to know law legal filings. I can't speak for other areas of the law. I would guess that generally speaking, it should just be, it's not advisable to use generative AI for any legal filings, but I can speak specifically to know that you should not probably be using it for your right to know because of what we've seen. So jumping to the question that everybody wants to ask, why shouldn't I use it? So I asked generative AI, I forget which one it was that I asked, if you should use it. And AI itself said, don't use generative AI as a reliable substitute for a human attorney. So I think in taking a step back, what we're kind of seeing happen is people are relying upon generative AI as their legal counsel now with right to know appeals and right to know requests, more on the appeal side of things. And obviously that's problematic for reasons we'll see in a little bit, but we're seeing it much more with requesters doing it. We have not seen, thankfully, solicitors or agency counsel relying upon generative AI. They may use it, but they're proofing it well enough and catching any errors that it's generating if they are using it. But we're seeing it much more, like I said, with requesters using it as a tool. And don't get me wrong, generative AI can be a writing and grammar tool. It can be a great assister there. It's not a reliable legal one. And that's based in large part because it typically tells you what you want to hear, or maybe what it thinks you want to hear. So as a requester, if you're coming to generative AI, the AI is going to pick up on the fact that you want access to these records. So it's going to tell you what you want to hear. It's going to tell you how to get access to these records. And as the next slide shows, what's happening is it's spitting out completely unreliable information to try to help a requester get access to the records because that's what it thinks the requester wants to hear, and that's what it thinks the requester wants to do, and it wants to help the requester do that. We have seen it be completely unreliable on many different levels. And some of these forms that it takes, they get referred to as AI hallucinations. I don't know if you've not heard that term yet, that's kind of tossed around a lot. And basically, it's AI generating inaccurate information. We've seen it cite to non-existent cases in quotes. We've seen it make up cases in quotes. We're going to look at some examples in the coming slides. From time to time, it will reference outdated information and not pick up on the fact that there has been more recent case law that overrules a previous case law. It really struggles with recognizing legal nuances. So it will not pick up on factual differences or distinguishing factors within a case, and it will jump to overbroad generalizations and have kind of a one size fits all approach to it. So it may take some very nuanced legal principle and apply it generally and say, oh, this whole area of records are now public. And it's just not the case. The court specifically ruled it was only records in that specific narrow area related to a specific request. So it fails to pick up on those problems or those distinguishing natures. Moving on to the next slide, generative AI misrepresentation. So a classic thing that we see is it will cite to a case and say it stands for a legal principle. But then when you go upon review and do a closer look, the case has nothing to do with the legal principle the requester and I say requester because that's who's been using this, but it will have nothing to do with the legal principle the requester is trying to prove. And we've even, as it continues to, as it continues to develop, the citation may be correct. Sometimes the citation and quote may be correct, but the proposition is completely taken out of context. Um, and I want to emphasize again, I'm not picking on requesters. It's just requesters have been the ones that have been using generative AI to this point, and there hasn't been any use, to our knowledge, by like I said, agency counsel or solicitors. So now looking at some examples, and then we're going to get into some tips of dealing with AI and generative AI as we work through it. This first slide makes this argument that an agency, and it has a quote, and it makes a legal statement and then has a quote. The quote is not right. There's no such quote like that. That quote doesn't exist. The final determination does not exist. There is a 2016-1537 final determination. It is not that one, and it doesn't even discuss the issues that are that were presented by the requester. So it basically made this up. On the next slide, this one was a little more tricky because the case is the case citation is correct. Commonwealth v. Donahue. The actual 98A 3rd 1223 is correct. That quote does not appear anywhere in the case. Additionally, I don't think that a quote appears anywhere in any case because it's not correct. The next one is even more egregious because this case does not exist at all. And it's interesting because within the last week or two in preparing for this, Google not only had this listed, it being fake, you could pick up on it and it would generate it, but it also gave a synopsis of it. And it's almost like AI is producing validation for its hallucinations. So it's got, not only does it have just a quick blurb about the case, it gives a whole factual synopsis or case synopsis and breakdown of that case. So almost creating a secondary layer of validation for its own hallucinations, which is very interesting. On the next one, not only is it doing it with case law, not only is it doing with final determinations of the OOR, we've seen it doing it with just policy, and we've seen it doing it especially with the OOR's policy. It will grab from time to time and misrepresent different agency policies and claim that the policy stands for something it doesn't, or say that the agency has a certain policy and doesn't. But we've seen it especially with using OOR policy in the appeals, and just outright saying that we've clearly stated something and we haven't, or we've repeatedly said something and we haven't, or it tries to clarify that we've defined open for business as the ability to receive right to know requests. Well, if it's just merely the ability to receive right to know requests, then it's 24/7 because you can submit them via email, and that's not what the law says. So you have to be alert to the not only misrepresentation of case law and final terminations, but also policy. Some of the tips in dealing with this, as we look at requester tips. Like I've said, our suggestion for now and our recommendation for now is that you do not use generative AI in legal submissions. It's just too unreliable. I would even go a step further to say it's even risky to use it to help develop or organize your argument, especially if you are a requester, because you don't have a legal background, and it does these hallucinations and creation of policy and laws that might not exist that can get very problematic to you as a requester. And it does so because I put this as a big warning. You're responsible for the accuracy of what you submit to the OOR. And if you go to court and eventually end up in court, you are responsible for the accuracy of what you submit to the court. This is not an insignificant responsibility that you have either before the OOR or before the court. And keep in mind that our appeal form, when you submit a form appeal to us, says that you verify that the statements are true, subject to the penalties of the statute section there, the code that's stated. So saying a case says X when it actually says Y could be considered a false or misleading statement. And especially if your brief, submission, or appeal is full of these type of misrepresentations, misquotes, and fake case law. And I would say, going even further than that, if we have pointed it out to you as a requester and you're doing it again and you're resubmitting the same errors again, you could be looking at sanctions. And you really, as much as you don't want to do it before the Office of Open Records, you definitely do not want to do it going before the court. Moving on to agency tips. What are some things here that can help the agencies work through this? I want to emphasize the misrepresentations and the fake case law that we're seeing we're seeing it happening at the appeal stage. So for those of you who are open records officers, and I'm going to say arrows because that's what agency open records officers, what we refer to them as arrows. I don't want to have all of this, put any undue pressure or stress on you. We haven't seen it as problematic at the request stage. But I do want to caution you that if you have a requester who files a request with you and they make some novel legal argument or some broad generalization, like say, for example, they say the Pennsylvania Supreme Court recently held that Section B10 no longer applies and that pre-decisional deliberative records are now public. If they make something that broad and grand, and even cite to a site that says it and say this case says it, I would contact your solicitor. If it's something you historically have not released as an agency, I would reach out to your solicitor to confirm. And I would especially do it in the personal information context. Say somebody submits a request and says, hey, you need to release these records to me because the United States Supreme Court just said that Social Security numbers are now public in the context of linking them to income so we can see what taxpayer dollars are being used to pay people's salaries. That's not going to be unreliable. The Supreme Court has not said that Social Security numbers are public. So if something that grand and that big and that groundbreaking, policy changing comes down, bounce that off your solicitor before you just blindly trust releasing that information. For solicitors and agency counsel, I would ask that if you get a requester that is making these arguments and using fake case law, fake citations, fake quotations, and you pick up on it and are able to decipher it, please point that out to the appeals officer. I'm not, we're still working through what this looks like as far as policy at the OOR and sanctions, but it doesn't hurt as an attorney if you want to raise some issues or make some points that you within your filings to explain how you think things should be handled, or to propose or make a motion that things be handled a certain way. We would consider that. Additionally, I'm not sure, we're not encouraging anything, but to the extent that agencies exercise their discretion to handle some of these matters in court, the courts could give us guidance as well on them, and we would be open to anything that the courts would issue on that. I would just ask that you keep us updated on anything that you may handle, right to know and AI related, because there are times we don't get notification from the courts that decisions have been made outside an appeal. And of course, these are generating all kinds of questions. So I just want to run down some real quick. Can an agency deny a request when a requester uses generative AI? Not at this time. There's no provision within the law. There's no court decision that permits it. Is the OOR denying appeals when generative AI is used? We're not at this time. We're still working through what this is all going to look like, how this is going to work, and try to work through an efficient and effective way that's going to work. And then the last couple questions, there are, how should an arrow handle a request, and how should the solicitor or agency counsel handle a request or even an appeal? And I'd say, just like any other request, look at it, determine whether or not it's a record of the agency, and then look to the exemptions and say, is this something that we are permitted to withhold, or is this something that we should be releasing. And like I pointed out with the solicitors and agency counsel, we would just ask that you continually, as much as you can, point out to the appeals officer any inaccuracy or fake sites that you see generated by AI. And I would also encourage attorneys, if you are using generative AI, be very, very, very careful. There's many pitfalls and many dangerous paths you can go down in relying completely upon that. So without going into any more detail on that, I am going to turn it over to Kyle to do a rundown of the case law update. And if there's time after his, we might hang around and try to answer some of the questions that maybe didn't get answered in the chat section. Kyle, it's all yours.
Thank you, Nathan. Good morning, everyone. This is a brief case law update of cases from the last year. Maybe in next year's case law update, we'll get some cases about the use of AI. But in 2025, these cases I'm going to present to you are all reported opinions of either the Commonwealth or the Supreme Court, and the reason for that is they're precedential. So I'd like to share them with you. The first two involve the issue of specificity. So whether a request has sufficient specificity to enable the agency to conduct a search for records. Now, the first case is Grime versus PA State Police. So in this request, to give you some background, it was a 7-item request. The 7th item was a request for all emails sent to or exchanged amongst the PSP containing certain keyword terms. Our appeals officer found that item 7, the request for emails regarding certain keywords, was insufficiently specific because that item was set apart from the prior 6. And thus, the appeals officer found that the keywords were too general and unrelated to the other item's subject matter. The court disagreed with us and found that item 7 is related to the context of the other items. So, in other words, 14 keywords in item number 7 related to one another and to item numbers 1 through 6. Some takeaways for this case: a request does not need to be perfectly drafted. So it only needs to provide enough information to inform the agency of what records are being requested. That's really important to keep in mind. Another takeaway is that context is really important when dealing with specificity cases. So take a look, read through the entire request to ensure that you're not missing crucial contextual clues that could help you conduct a search if you're the agency or the agency open records officer. On the next slide is another court case involving specificity, also out of the Commonwealth Court. This one's SEPTA versus Anderson. The background for this request was it was a request for a whole host of records regarding proposed construction of a new arena for the Philadelphia 76ers, basically. Our appeals officer looked through the request and determined that some parts of the request were specific and some parts were not. The Commonwealth Court affirmed us on that reason. And in doing so, the court noted that the appeals officer didn't modify or refashion the request. The exact quote was, "The OOR did not supply any additional qualifications or limiting language, but rather interpreted the items in context and parsed out those portions that satisfied the specificity test." So the takeaway from this case is that parts of a request may be specific and parts may be inspecific. Agencies and agency open records officers should review the entire request with the mindset that are there any portions in here that we understand? Just because a request may be 50%, 75% inspecific doesn't mean that it's not specific for the remainder. So just keep that in mind. Read the entire request. The next slide has a case involving evidence and agencies meeting their burden of proof. And some background on this case is the request sought the full names of correctional officers. In 2010, there was a Commonwealth Court case, Stein, which found that where the Commonwealth Court found that the agency met their burden of proving that the full names of correctional officers are exempt. Based upon that case, and subsequent to it, the OOR issued numerous final determinations denying access to this information and relying upon the Stein case. In this specific case, we did the same thing. We relied upon Stein and those previous final determinations spanning back over a decade. However, the Commonwealth Court reversed us and directed access to the records. The court noted that there's no per se rule against the release of this specific information. So the court's holding in Stein in 2010 was based upon the evidence before the court at the time. So the takeaway from this case is that unless it's information or records specifically listed in the right to know law as exempt, an agency must meet its burden of proof each and every time. And in other words, just because the full names of correctional officers were held to be exempt in 2010 doesn't mean that they're necessarily exempt now. The agency has to meet their burden of proof. On the next slide, there's an interesting case. It involves records of state-related institutions like Penn State. But the main focus, I think, for all of you is about the cloud-based record component. Some background for this case is the request sought materials hosted on Diligent, which is a file sharing program used by the Penn State Board of Trustees. Access for the trustees within Diligent, it was read-only, meaning that board members could review the files, but they couldn't, download, save, share them. Based upon an older Commonwealth Court case, we found that the records were records of the Departments of Education and Agriculture. And the reason is both of those departments, their secretaries, are ex officio members of the Penn State Board of Trustees. Thus, we found that their receipt of the information through Diligent, by virtue of their ex officio status, made the records of the department. The court affirmed the OOR on this, noting specifically as to the read-only access, component here, that noting that holding otherwise would perversely incentivize agencies and affected third parties to utilize remote servers and/or cloud-based services in order to ensure that they would no longer need to disclose what would otherwise constitute public access. The court added that the departments have constructive possession of the requested materials, despite their read-only nature. This is by virtue of the fact that those materials have been specifically made available to the secretaries in accordance with their positions as ex officio board members. There's not a host of court cases and legal materials out there regarding cloud-based records under the right to know law. But if you have a situation involving access to information which is saved in a file sharing platform or on the cloud somewhere, or read-only records, take a look at this case because it might prove helpful to you. The next case involves third-party records and a section of the right to know law called 506D. Section 506D of the right to know law makes certain records in the possession of a third-party contractor accessible. What normally happens is you make the request for those records to the agency, and the agency obtains them from the third-party contractor. That's how the law is set up. In this case, the court found that Section 506 does not require one agency to obtain from another agency information that the requester could get from that other agency directly. So, this applies to situations where there's an alleged contractual relationship between agencies. in other words. The court reasoned that when a contracting party is another agency already subject to the right to know law, public access is already assured. There is no need or purpose for involvement of an agency that does not possess the record sought, where another agency does possess those records and indeed is their originator. The court further reasoned that the agency in this specific case wasn't in a position to know what exemptions from disclosure the other agency might be entitled to assert regarding the requested information. So the surer way to preserve exemptions from disclosure to which the other agency may be entitled would be to avoid making that agency a middleman. Notably, in this case, the Supreme Court has partially granted a petition for allowance of appeal. So we're going to get further clarification on this from the Pennsylvania Supreme Court. But I just wanted to flag the case since it's the current state of the law with respect to arrangements between agencies. Janelle, can you do the next slide? There's a host of other Commonwealth Court cases that I'd like to treat a little bit in a little bit more summary form, but I wanted to note them for you. First, Department of Revenue versus Haverstick. This case involved a spreadsheet containing weekly lottery sales data for retailers. The court found that the spreadsheet was a financial record. Financial records aren't subject to the right to know law's trade secret or confidential proprietary information exemption, or a bunch of other exemptions. Ultimately, the agency didn't prove that the information in the spreadsheet was exempt and ordered its disclosure. Any takeaway from that case would be, the definition of financial record is a little bit broader than what's contained in the right to know law itself. So if you have an instance where there's a record that looks like it might be a financial record, but doesn't neatly fit in the confines of the definition of financial record under the right to know law, take a look at this case because it could provide you some additional guidance there. The next one is Pencrest School District v. Rogers. In this one, the Commonwealth Court found that emails sent by board members using their personal emails may constitute records of the agency if they are sent in the board members' official capacities and discuss agency business. The court rejected an argument that a single board member can't bind the agency. So that factor is irrelevant. We look to whether an email sent by a single board member, whether it's being sent in their official capacity and discusses agency business. A couple more cases on the next slide. Commonwealth Charter Academy versus SPCA. In this one, the court found that education records under FERPA may be subject to access redacted of certain personally identifiable information. Under FERPA, it's commonly referred to as PII, and there's a regulation that defines what constitutes that information. So under FERPA, student handwriting may be PII, but parent handwriting is not. The court also rejected an argument that the parent handwriting was protected by the right to privacy. Another kind of takeaway from this case is the court found that the agency could not provide the information in an alternate format. Forms were requested, so the forms needed to be provided with redactions. The agency couldn't just extrapolate certain information from the forms and provide a spreadsheet instead. In the next case, Bethke versus City of Philadelphia, the takeaway from this case is failure to appeal an OOR final determination granting access to records results in a mandatory and ministerial duty to provide those records. Further, if you fail to appeal an OOR final determination, it results in the loss of an opportunity to raise exemptions or submit new evidence. So, if as an agency you receive a final determination that you don't agree with, your legal remedy is to appeal. Otherwise, it'll become a binding final order and you're basically out of court at that point. And two more Commonwealth Courts cases on the next slide. These are the last of the Commonwealth Court cases I wanted to flag for this year. The first is Trethaway versus Downingtown Area School District. And I only want to talk about this one in the most general sense. The opinion is heavy on details with respect to copyright, trade secrets, and confidential proprietary information. So if you have a question regarding those topics, this particular decision would be a great starting point. But other than that, I'm not going to get into that case too much. And the last one for Commonwealth Court is Voss versus PA Gaming Control Board. This was an en banc opinion, meant it was heard by the full Commonwealth Court. It found that a government license wasn't a contract. So in this instance, the government license was an entitlement to engage in a valuable activity within a regulatory framework, but that it wasn't an actual contract. Also, adherence to that regulatory framework wasn't an agreement to take on a government function of the agency. So in other words, the agency had no obligation to obtain records from a third party in this instance. My final two cases I'd like to discuss briefly are both from the Pennsylvania Supreme Court. The first one involves social media. Pencrest School District versus Cagle. And the specific issue in this case going up was, were social media posts by a board member a record of the agency? So social media posts by a board member on that board member's personal social media page, specifically Facebook, is that a record of the agency? The Supreme Court affirmed the Commonwealth Court, which set forth a variety of non-exclusive factors to consider and remanded to the trial court. So the takeaway here is there's no firm rule saying social media posts by a board member or someone similarly situated are always public or they're not public. It's murkier. We have to look to a lot of facts and context to determine whether that specific social media post is a record of the agency itself. Some of those factors are, you look into whether what the board members' official capacities to make the post were they pressured to do so by the agency? Does it benefit the agency? What does the remainder of their social media page look like? Does it look like it's an official page? A whole host of factors to consider when dealing with social media posts. And finally, Mezzacappa versus Northampton County. This one deals with mugshots. And the Supreme Court reversed the Commonwealth Court and found that mugshots are generally not subject to public access. The court reasoned that mugshots are identifiable descriptions, which then made them criminal history record information under the Criminal History Record Information Act. The court had an extensive analysis, but one of the points they made is the phrase, a picture's worth 1,000 words. So relying upon that line of reasoning, these pictures are identifiable descriptions. CRIA, the Criminal History Record Information Act, limits the disclosure of criminal history record information, and thus mugshots can only be disseminated as set forth under CRIA. If you have a case with mugshots or any questions about this case and how it intersects with CRIA, the only thing I'd like to note is it was decided under a prior version of CRIA. Some of the language has now changed very recently. So definitely run those questions by your solicitor. But for the most part, the general proposition in Mezzacappa is true that mugshots are generally not subject to public access and that they can only be disseminated as set forth under CRIA. And with that concludes my case law update for this year. If you have any questions about those cases, feel free to ask or submit a question through any of the means set forth here.
All right, Kyle, can you see that? I don't know if you have your chat up. Can you see the question that was just asked? You want me to read it to you?
Yeah, I do see it. So what that means, Don, is that in that specific case, the agency was making an argument that the power of, the single board member can't bind the agency, meaning that a single board member's word doesn't bind the agency. Normally, you need a quorum of the board member to, make policy, whatnot. So, the court rejected that argument, saying that, that's not really a consideration. What we're looking at is whether the agency, or whether the board member is discussing agency business and, are they doing so at the behest of the agency or furthering the agency's interests?
All right, I'm going to jump in on this next one. There has not been any legislation passed on commercial requesters and the right to know law. There has been over the 10 years a number of different proposed bills and discussions on it. If you want to reach out, we could give you an update on, just reach out to us after the training and we could, provide you the various bills that are related to that. No, we did not chat about vexatious requesters today. We just chatted about AI and a case law update.
Leah, I'll address Leah's question here about tips on working on requests that yield tens of thousands of email results yet still fall under what the OOR considers to be sufficiently specific. So one tool outside of the OOR's involvement, I've seen this work to great success, is an agreement to do a rolling production schedule. It's consider an agreement wherein you'll provide the requester X amount of records every month. That may make it a little bit easier on your end, and from what I've seen, most requesters are okay with that arrangement. Before the OOR, there's certain relief that we can grant in terms of extended time to be able to review and review a lot of records and raise exemptions. But outside of our office's involvement in an appeal, I would say that the best tip I can give is consider the rolling production schedule.
And I just want to build on that too. Another, and it's preemptive and proactive, is to really review your record retention and to only keep records that you're required to do. And email is notorious for building up a large amount of records that do not need to be maintained under the Commonwealth retention policies that the Museum Commission develops. That's really crucial and critical to this as much as anything else.
Yeah. One more tip I have along those lines is do consider reaching out to the requester outside of seeking any kind of production schedule, just to get a better feel on what they might actually want. I've seen various instances where an agency and requester are able to work out an arrangement where this is what they really want. They don't want duplicates. They don't want, it's more mailing list emails you got. That communication might be fruitful for you in order to winnow down the amount of records you need to review and provide.
Just to follow up, I saw there was another question on commercial requests. I know, again, there's lobbying on both sides of it that goes on with respect to commercial requesters, with agencies expressing concern and the commercial requesters expressing, and the commercial entities expressing concern as well. To my knowledge, there is no action on it. I don't foresee anything in the near future passing on it, but that's just where we stand right now. Like I said, we can provide copies of proposed bills.
I'll start with the latest question, work my way up. Are some email messages considered pre-decisional and thus exempt from being public records? Yes, emails can possibly constitute pre-decisional records that are exempt under the right to know law. However, the agency has the burden of proving that. So just keep that in mind. That there's a burden of proof associated with that, and the agency needs to show that those records are internal, pre-decisional, and deliberative in content.
I'll take Joe's question. It's how are personal emails handled, assuming an elected official won't produce them? If they are personal emails, they're not subject to the right to know law because they're personal. If they are agency records and are on the individual's personal device, they are still considered agency records. It would be the responsibility of the agency to obtain those records from that person and provide them, if they are public records, to the requester. That's a very simplistic statement. There's a number of legal complexities that could come into that. If you're still curious what those are, please feel free to reach out. We can give you some final determinations. And there's even some good case law out there from the courts that walk through the process that goes through determining the difference between personal and agency records.
For Eric's question about the 30-day extension. So if an agency invokes a 30-day extension to respond to a request, those are calendar days, so 30 calendar days. They do include weekends and office closure dates. Business days are at the initial front 5-day period. So an agency would have 5 business days and then 30 calendar days to respond. I hope that helps to clarify.
To Leah, as far as can you enforce the checkbox that people need to check it, otherwise it may result in the denial of the request. Our stance on that is, common sense and good government. If it's just a minor technicality and somebody forgot to check a box, I think that can be a little draconian in denying the request based upon that. But I know there are circumstances where denying that would be appropriate. And I hate to say depends, but just use common sense and good judgment on that approach to that and be reasonable.
For Brenda's question, can you explain when there would be a third party to contact on a right to know law request? The most common reason that we see is an agency contractor has marked their materials as a trade secret or confidential proprietary information. They're supposed to technically, mark those records when they give them to you. But if you have that notice that an agency a contractor believes that some of their records in your possession constitute a trade secret or confidential proprietary information, that would be probably the most common reason why a third party would require a notice. Some other examples are there's a safety or security interest. It's for example, someone has concerns about the release of their record because there are security related beliefs that might necessitate notice.
Nathan, we have time for you guys to answer one more, and then we're going to have to jump to Sunshine Act. Perhaps you can answer some in the chat after that.
Okay.
I'll just jump back into if the required form is not completed, I'll answer that one. That gets into anonymous requests. There is a number of final determinations that we've issued on those. Those are very fact-specific situations. So if you want to reach out to us after the training, we can provide some final determinations that address how we have ruled on that. Your fact scenario could be a little different, which could result in a different situation. It just depends. But generally speaking, there are final determinations that should be able to walk you through what our position is on those. And with that, thank you again. Like I said, you can reach out with additional questions. I will turn it over to Liz now for the sunshine section of the training.
All right. Thank you. Chock full of information and always good questions. We're going to wait a minute while we switch to the other slides. Right, that was fast. Okay. Now we get to talk about the Sunshine Act. And if we could go ahead and start on the first slide. All right, so here's a picture of why public meetings matter. And if you don't know, this is what a Chick-fil-A could look like pretty much on any day of the week, anywhere you go, except Sundays, because they're closed on Sundays. They are notorious for creating significant backup surrounding the restaurants. So we have one here where I live in Lancaster County, and you kind of know which lanes to avoid to go in, despite how hard those employees work out in the cold and getting your food to you. It creates a backup. So, one of the key things about why we have a Sunshine Act is that you want to know when to go to a meeting, right? If it's just sort of routine things, I don't know, maybe I will, maybe I won't go. But if you get wind that something like a Chick-fil-A is coming to town that could disrupt your life, people show up. Here's an example of a meeting when there was a proposed Chick-fil-A in Camp Hill, which is outside of Harrisburg. It became quite a high level participation at these meetings. If you look at this picture, this is not the typical turnout for a Camp Hill borough meeting. And there was a lot of concern about traffic because of where it's being located. And eventually Camp Hill denied it. And the developer thought they found a technical reason that the violation was improper. They violated the Sunshine Act, which is what Pennsylvania's open meetings law is. And what happened was that went to court, and the court said, actually, it's fine. The rejection is fine and upheld. And to this day, there's no Chick-fil-A in Camp Hill. I don't know where the nearest one is, but this level of outpouring is what a big reason I think probably why it was stopped, that the council members realized there was a lot of opposition. They heard people, they saw this, and it led to a vocal outcry against this. The next slide, I want to give you some of those legally kind of notices I have to give before I go too far. The first one is we don't provide legal advice. The second one is we have no legal authority on the Sunshine Act. There's one little line thrown into the right to know law that says that we shall provide training. And there, as a result, we've become the default experts on the Sunshine Act, even though we have no legal authority to opine on this in terms of whether or not something was a violation. That's left to the courts. But it is something that is, we often provide advice, and there's no other authority to kind of gravitate to. You can't email judges and ask them for their opinion on or their technical rules on how to handle Sunshine Act 6. So that is why we are here. And nothing is legally binding. And I think one of the most interesting things about the Sunshine Act is if you really read it and look at it and kind of digest it, it's a lot of common sense. And if you go to the next slide, we could talk about that. So first, here's our roadmap. We're going to talk about why there's a Sunshine Act, and then kind of different things: advertising requirements, posting of agenda, public observance and deliberations, and challenging alleged violations. So we're going to go through it all, and we will try to have questions in the throughout, but if not, we will answer them at the end. All right, so why is there a Sunshine Act? If you are someone who helps run these meetings, it may seem kind of draconian, like all these little rules, little things, why would you do this? And there's a reason. And, when I started studying this, it's interesting. It seems like the public meeting and having the public coming to speak at a meeting is a classic American feature of meetings that occurs all the time over the country. It seems ingrained in the Constitution. I particularly have images in New England of people in the 1800s going to meetings. And it turns out it's a fairly new phenomenon to make it required. It's not in the U.S. Constitution. It's not in the Bill of Rights. And it sort of started a little bit slowly, not until 1950 that they started putting this in the state level of requiring open meetings. And then, does anyone know what this picture is from? Put in the chat if you know what this picture is from. You can tell by what they're wearing, what decade it is. Yes, Allison, very good. Yes, Judy. Watergate. Watergate, yes, Margaret. Yes, so this is Watergate. It upended a lot of things in American government and leading to a demand and actually a pretty impressively quick response to put more transparency in government. And so by 1976, all states and the federal government have some type of open meetings law. And going to the next slide, you will see that in Pennsylvania, the current version we have was enacted in 1986. It was last legally amended in 2021. And that provision, basically what it did was say that you have to provide an agenda in advance of a meeting, which we'll talk about more later. But given that was the only advance, there's still no provision in there directly related to addressing virtual meetings. There's a lot of chat after the COVID shutdown led to having a lot of virtual meetings about putting things in there about virtual meetings, but really it's just applying the existence of Zoom to the current laws. And the next slide. The essence of the Sunshine Act. Again, like I mentioned, if you kind of understand the essence, a lot of everything fall in place. And I'm going to read this word for word. Deliberations and final actions performed by a quorum of governing body, such as the Board of Trustees, this example that we gave here, but for you to be your board, must occur at a public meeting that was advertised to the public. So that is kind of the essence. So you need to kind of know what's going to be talked about. You need to have the public be able to see deliberations and final actions, to be able to speak beforehand at a public meeting that was advertised to the public. That is kind of the essence of the Sunshine Act. Next slide. All right, so the public has a right to know how to attend, virtually, in person. For either of those, here's the link, or here's where you go, and here's what time it is. Clearly, that's a basic tenet of it. Knowing what is being discussed. If that Chick-fil-A is being discussed, or they're talking about another construction project, or talking about building a new police department building, if those are things that you care about, you need to know when they are going to be discussed, so that you know when you want to attend and have your voice heard. And then another one that only applies to school districts and municipalities, allowing the public to speak before the vote. So beyond, and then observe deliberations of a quorum. And there's some limited exceptions we'll talk about. Observe final actions. And the public has a right to object to alleged violations and seek relief from court. So those are the basic tenets. I need to know when and where, what's being discussed. I should be able to speak before a final vote. I should observe deliberations when a quorum is meeting, and observe the final actions. Final actions means the vote. And then also have the chance to allege violations in court. Let's pack a lot, so we're going to kind of go through some of these. All right, advertising requirements. Now, this may seem antiquated, but this is the current law, that you must post the regular meeting schedule 3 days before the first meeting of the year. That includes the date and time and location and virtual, and the newspaper of general circulation, which is a lot to understand, given that newspapers have changed a lot since 1986 in terms of newspapers. And there's a lot of legislation and chatter in Harrisburg about updating that to modernize that newspaper of general circulation. And like anything, there's a lot of back and forth and pluses and minuses, but that is currently the law right now. And I gave an example of one that was done in East Lampeter Township. All right, next. Here's why that advertising is important. If you fail to advertise properly according to that law, you may need to cancel your meeting. And that happened or what happened in the meeting may be deemed null. There was an example where the public wasn't able to view a meeting. And it was a really important meeting, involved furloughing over 200 district employees. The link did not work. Something, everyone's been on a Zoom that doesn't work. And it didn't work. They voted on this. And someone said, whoa, all these people wanted to watch and they weren't able to because of the link problem. And the judge said, yeah, that violated the Sunshine Act. And so the unfortunate lesson is that if something doesn't work, you're probably going to have to go. The link doesn't work, and you advertised it, you're probably going to have to cancel the meeting. So another reason to check technology. Now, special added meetings. So it's January 3rd. You post your meetings for the year, but things come up. There may be weather issues, or you have a new important meeting you have to do. The Sunshine Act has anticipated that. And here's the key is if you want to add meetings, you do have to do a notification at least 24 hours before the meeting. And all the same other requirements, the date and time and location, including a link, and also the newspaper of general circulation. You have to post it in. So there is a provision for that. Emergency meetings. Okay. And there's another scenario. What if it's a super duper emergency where 24 hours is not possible? The newspaper's already gone to print. The bar is very high. It must be a real or potential emergency involving a clear and present danger to life or property. It still has to be open, but if you feel you've met that bar, there's a true emergency and you don't have 24 hours, you don't have to post it, but it still must be open to the public. Public comment. Now I'm going to turn over to my colleague, Dylan.
All right, yeah, so I'm going to talk a little bit about the public comment requirements as well as after that the agenda requirements under the Act. So with respect to public comment, agencies are required to permit members of the public to comment at their meetings, and that is on issues that are or may be before the board. So like was discussed earlier, you may be having that deliberation, that official action taking place at your meeting and on your agenda. And of course, a member of the public can comment on those things. But it doesn't just have to be that sort of thing. It can be something that could be before your board related to your agency in the future. So it doesn't necessarily just have to be on things that are on the agenda. And the agencies must provide a reasonable opportunity. That's the specific phrase that's used in the Sunshine Act itself, is reasonable opportunity. So, we can talk a little bit about what that might mean here in terms of the kinds of rules that you can establish. So one is that, of course, agencies can establish some sort of basic rules around public comment, such as time limits. We've indicated that something like 3 minutes is fairly common, although obviously longer than that may be appropriate in some situations and things like that. Agencies can limit that public comment period to just residents and taxpayers. So if you're a municipality or something like that, for example, you can choose to limit the public comment to just your residents and taxpayers. There's nothing in the Sunshine Act that prohibits members of the public from using their public comment time to ask questions. There's also nothing that requires you to answer those questions, but obviously it may be helpful to do so. And sort of in the interest and in the spirit of the Sunshine Act, if you think about what these provisions can do in terms of allowing members of the public to get their views out there and on the record in terms of the minutes, we generally encourage agencies to really be flexible with these kinds of requirements as much as is reasonably possible, because you really want to sort of serve the purpose of the Sunshine Act in terms of public transparency and public participation. So next up here, I'm going to talk a little bit about the agenda requirements. Agencies are also required to post agendas before their meetings. So your agenda needs to be posted at least 24 hours before your meeting begins. So, if I'm going to have a meeting at 7 o'clock on Wednesday night, my agenda needs to be posted by 7 o'clock on Tuesday, although you may want to do it before then. So the agendas need to be posted at the location of the meeting itself and also at your main agency office and also on your agency website. So those are, those agendas need to be posted in those places. And you also want to have hard copies of your agenda available at the meeting itself so that members of the public can, follow along, see what's coming up next and things like that at the meeting while they're attending. So, and we will discuss, or Liz will discuss a little bit later on, these particular kinds of situations in a little bit more detail. But just to note that broadly speaking, these agenda requirements are applicable to those same kinds of meetings that Liz was talking about earlier, public meetings where that deliberation and final action is taking place. Things like if your members of your board are attending a conference, if they're in an executive session or a work session, these agenda requirements may not be applicable in those kinds of scenarios. So one of the most frequent questions that we get about the agenda requirements is, how specific does my agenda need to be? And, there's not sort of a single rule here necessarily, but we really encourage that those items need to really hone in on the specific, discrete, concrete issue that's being deliberated or voted on. It's not sufficient to just say we're going to discuss contracts or going to discuss payroll or something like that. It really needs to be clear what is being discussed, what's being voted on in specific, and you want to err on the side of specificity. And one way of thinking about this that I find useful personally is to sort of put yourself in the shoes of a member of the public who is viewing your agenda. It's posted 24 hours before. That member of the public is looking at it and they're making a decision. Do I want to attend this meeting? Do I want to comment on this issue? What's the kind of information that I would want to have in that position to know what I want to do, what I want to say? And so you really want to provide that kind of concrete and specific information for the people who are in that position. So next up, we have a little bit of discussion here on what the consequences can be for violating the agenda provisions. And this is largely in line with the provisions as a whole, like Liz was saying before. If the provisions of the Sunshine Act are violated, then a meeting may need to be canceled, or business conducted in a meeting may need to be avoided. So obviously there can be lots of headaches there. And of course, additionally, there's the issue of transparency and the appearance of transparency. Even if an agenda is, if there's a mistake that happens or a technical issue or whatever it is, obviously there's the members of the public have an interest in seeing what's going to be discussed in advance like that. So you don't want to create the appearance of lack of transparency or things like that. And you also don't want to run afoul of these potential consequences that can arise with these agenda provisions. So lastly, up on the agenda provisions, I just want to talk about one thing here. There has recently been an update on this just within the past few weeks. In this case, Coleman versus Parkland School District. And you can go onto our FAQ page on our website under the Sunshine Act page. Number 18 on that FAQ is about the agenda provisions and includes the link to the full decision here if you want to review that or your solicitor wants to review that. But let's say that you have your agenda posted and you want to make changes. So it's within 24 hours of your meeting and you want to make changes to your agenda. What the Supreme Court here has clarified is that those changes must be approved by a majority vote. The agency has to announce what the changes are going to be, and that updated agenda then also needs to be posted, and that updated posting would need to happen within 24 hours of the meeting. So those are these sort of critical elements if you're going to be looking to change your agenda at the last minute. Again, this is just recently updated. So if you want to see that full decision, you can reference that as it's linked on our FAQ page from the Supreme Court. All right, and now I will turn it back over to Liz for the next section.
Still, and I see the questions are flying and we will do our best to answer them. And some of them, the answer might be it depends, which leads to a very long answer, but we will do our best. All right, so now you've advertised the meeting, you put out the agenda, you have everything set, and now it's time to get to the meeting started and allow people to observe deliberations and final actions. Here's the meat of the law. First of all, what is a meeting? There are a lot of technical things that go into what defines a meeting in Pennsylvania in terms of being subject to the Sunshine Act. So I'm going to read this quote. Any prearranged gathering of an agency which is attended or participated in by a quorum of the members of an agency held for the purpose of deliberating agency business or taking official action. I encourage you, if you are not sure if something is a meeting, go back to this message, read every single word in this and see if it checks all the boxes, because all of these things are important, that it's prearranged, that there's a quorum, and that you're deliberating agency business or taking official action. So first of all, what is official action? Again, not an easy answer with a lot of official words. So I'm going to go slowly through these. Here's 4 categories. Recommendations made by an agency pursuant to statutes, ordinance, or executive order. The establishment of policy by an agency. The decisions on agency business made by an agency. And the vote by any agency or on any motion, proposal, resolution, rule, regulation, ordinance, report, or order. So again, if you're not sure, go back to this of what is official action. Agency business versus administrative action. Imagine how everything would go to a crawl if you all had to vote on had to do every single decision you made in a public meeting. Should we make 30 copies of this or 10 copies of this? Should we have the parade on this day or this day? Think about that kind of stuff. So the Sunshine Act recognizes you can't do everything in a meeting. So what is agency business? Agency business it deals with the enactment of laws, policy, or regulations, the creation of liability by contract, or the adjudication of rights, duties, and responsibilities. Whereas administrative action is a carrying out of something you decided. So let's say agency business, you're trying to decide who to award the waste management contract to in your municipality. And you choose the company. And then you have to decide, well, should we order the red recycling boxes or the green recycling boxes? You don't have to do that in a vote. You can do that as administrative action, but that contract decision should be fully on board with the Sunshine Act, whereas deciding sort of the details of that contract can be considered administrative action. All right, now what is deliberation? That is discussion of agency business held for the purpose of making a decision. So it's not just the exchanging of facts such as what time is it or what are we doing in the office tomorrow. It's agency business held for the purpose of making a decision. So it's more than just chatter, it's deliberation. All right, when can a quorum assemble outside of a public meeting? Now, let's think about this. Let's say a bunch of people in your board decide to go to a girls' basketball game. If you go there and you sit down and there's a quorum sitting there, you don't have to go, oh my gosh, we can't sit together. There's a quorum of us. What's going to happen? And scatter across the room, across the arena. You can be together and sit together at the girls' high school basketball game. So there's those kind of social situations, but there's also the administrative action I mentioned. It's like choosing the color of the trash can. A conference or work session, that's when there is a session of you all gathering as official members of a board or a council, and there's no deliberation or official action. You're just receiving information. And the last one is executive session, which we get a lot of questions for, and I will address that as we go forward. What's a conference? This is sort of a training program or a session arranged, and it's conducted for the sole purpose of providing information to agency members. So if you are receiving information, you can ask the person presenting that information questions. You do not have to have that open to the public. So if someone is giving you information about a program that they'd like to come to your school district or something, and they give you information, you can ask that person questions, but what you can't do is then turn to a school board member and say, well, what do you think about this program? I think it's great. I have concerns. That falls into deliberation. So as long as you stay on the straight and narrow of just providing, receiving information and not deliberating, it's okay to have it be considered a conference and not have the public attend. But you can have the public attend. I know a lot of school districts and municipalities bring the public to work sessions to watch so they can hear the information as well. It's a great idea in some situations. Okay, so characteristics of a work session: there's no deliberation, there's no final action, and as a result, no requirement of advertising or inclusion of the public, but you're always welcome to include them, and often makes things a little more transparent and easier for the public to understand what's going on if you do invite them to attend a work session. As I mentioned, you may choose to do that. Here's an example of a school district that did that. They said, hey, come on in, let's listen to that. So it is a good thing to do, to consider. Some other things. We get a lot of questions about committees. And this is basically all we're going to tell you, is that committees take official action or provide advice on agency matters are subject to all provisions of the Sunshine Act. So if it seems like they're taking official action or going to give some key advice to an agency, it's something that should be open to the public. Think about a bad actor, an agency that doesn't want the public to hear about their budget or something. They can just shove it all into the finance committee and not have the public hear anything. So the Sunshine Act requires that those be open to the public. What about recording of meetings? The public can record a meeting. They can bring their tripod in, they could just use their phone. They have the right to record a meeting. And on that note, though, agencies are not required to maintain any recordings. All that the Sunshine Act says is you must maintain minutes. Remember, this law was written back in 1986. And it is a frustration we hear from individuals, from citizens sometimes, because it's 2025. Why can't you just put the board meeting online for me to see whenever I want to watch it? But the law simply says you must maintain minutes. And so if you take a recording of a meeting and you want to put it on YouTube for perpetuity, great. But the law does not require it. You just must maintain minutes. All right, executive sessions. This is the one where I feel people are the most nervous about, which is a good example of knowing that you worry about doing the right thing. Okay, so there are a handful of reasons as to why you're allowed to go in executive session. And for those of you who don't know what executive session means, that means it's a gathering of a quorum behind closed doors. The public is not invited to hear the dialogue. There are no minutes produced from it. So it's a pretty awesome responsibility to make sure that you are doing it correctly, because you are shutting out the public. It is something that should not be considered lightly, and you should be very careful in how you decide if it's appropriate to go in executive session. All right, the first one is personnel matters. The Sunshine Act recognized that there may be things that the whole world doesn't need to hear, and that is including going into details whether or not to hire somebody, whether or not to terminate somebody, how to discipline. Now, the final decision, if you do hire or terminate somebody, that is public, but the reasons why that are discussed behind closed doors, they are not public. Labor negotiations, obviously, we'll go into all of these more. Purchasing or leasing or selling property. I'm not going to read these because we're going to go into each of them. I'm sorry, I got ahead of myself and excited about the personnel one. So we'll go to the next slide and talk about that. Oh, sorry. Public is not completely shelled out because they have to know executive session is happening, right? It can be held before, during, and after an open meeting, or announced for some future times. You can say, hey, we're going to wrap up our meeting, but we're going to go into executive session next Tuesday at 2:00. And you have to give a specific reason for the executive session. You can't just say, hey, we're going to executive session. You have to give a specific reason, and no official action can be taken. Any votes that result from the discussion must be done in the public session. All right, again, sort of about the agenda. How specific do you have to be? I cannot give you a magic answer or formula here, but you have to have something the Commonwealth Court has said that is meaningful. It must be more than some generalized term which tells the public nothing. To simply say personnel matters or litigation tells nothing. The reason stated must be sufficiently specific to inform those present that there is in reality a specific discrete matter or area which the board has determined should be discussed in an executive session. So give the public as much as you can without violating the reasons why it's an executive session, so they can go, oh yeah, I get it. That makes sense. That should be behind closed doors. All right, so moving on. Now, there has been one specific thing. For litigation matters, the Commonwealth Court has approved of a trial court's order. So this basically says if you're going into executive session to discuss litigation, you must name, when saying we're going into executive session, you must name the parties, docket number of the case, and the court in which it was filed. So that's very specific. For identifiable complaints or threatened litigation, you state the nature of the complaint, but not the identity of the complainant. So there is, if it's a case that's already been filed, you just go specific. If not, you kind of talk about the nature of the complaint, but not the identity of the complainant. Okay, here's where I jumped ahead. Personnel matters. So if you're discussing any matter involving the employment, appointment, termination, terms and conditions of employment, evaluation performance, promotion, or disciplining of current or prospective people, you can do that behind closed doors. So that's one that makes sense. So there's some exceptions. Filling the vacancy of an elected office. Because that's something the public voted for. Let's say you have a school board member resign. You need to speak about and talk to potential candidates in a public session about that, because that is something the public would typically vote on. It is something that it should be done in public. And then what if you're considering giving a whole class of employees a raise, not just one person? That should be discussed in public meeting. And also, the personnel matters only applies to employees of the agency. It does not apply to independent contractors or consultants. So those things about hiring or termination should be discussed in public meeting. One little quirk is just an FYI. I've not come across this happening, but the employees are the subject of any discussion that could typically be done behind closed doors in executive session. They can request that be moved to the public. And as I mentioned, I'm going to say this a lot when I go over these exemptions, any decision on the final action, termination, hiring, etc., must be public. Collective bargaining. All right, so when you're holding strategy sessions about collective bargaining, you kind of lose your ability to negotiate if the other side kind of knows if it's sort of out there in terms of what people are talking about. So if you go to the next slide, we go into more about that. We don't. So I'm sorry, we don't go that. So that's pretty simple. Basically, that's what we know about it. If you're talking about collective bargaining, you can do that behind closed doors. Property procurements. All right. So considering the purchase or lease of real property, that's something you can discuss behind closed doors. Exceptions. Some of these have exceptions. So collective bargaining allows you to kind of have negotiation sessions behind closed doors with the union. You can talk about things, negotiate, go back and forth. The property procurement is a little bit different about that. It does not explicitly permit negotiation sessions like that one. It's more for you to talk with your team about what kind of offer you want to make, that type of thing. And once you agree about something, there's no more executive session. It's about considering the procurement or leasing of property. And again, any decision on final action, purchase at X price, must be public. Litigation. There's a lot of things in litigation you want to discuss behind closed doors. And this one deals with consulting with an attorney or other professional advisor in connection with information or strategy on connection with litigation or things that you expect to be filed. Here we go for some exceptions. In order for this exemption to apply, an attorney or other professional advisor must be present. However, the presence of anyone else may render the exception inapplicable. So basically, who you're allowed to have an executive session plus an attorney or other person is all. If you throw someone else in there, you may have lost your right to have that in executive session. And also just the mere possibility of, technically it's certainly possible and feasible that one day we may be filing some litigation on this. Does not mean you can move behind executive session. There has to be a genuine possibility. And again, as I keep saying, any final decision must be public. Confidential information. Of course, you don't want to break the law. You don't want to have a Sunshine Act meeting where you break the law. So if there are things that would violate a lawful privilege or lead to the disclosure of information or confidentially protected by law, please go behind closed doors. That is an important one. This is limited, though, to information that's made confidential by law that is relevant to agency business. It's not something that the agency thinks should be confidential. It has to be tied to a law. We're going to skip this one. This only applies to colleges. Maybe if there's a few of you on there, you never know. And there's zero case history in this. All we know is you're allowed to discuss matters of academic admission or standings behind closed doors. That's all I know about that one. Public safety. You also don't want to jeopardize the public by discussing certain things for the whole wide world to see. Common sense, right? If it's disclosed, it would be reasonably likely to jeopardize or threaten public safety or preparedness or public protection. But that doesn't mean everything about public safety should be discussed behind closed doors. There are certainly a lot of things that won't threaten the safety of anyone or any buildings, but are about public safety. Example, hiring of a security consultant. That is something that should be discussed publicly. I share one story just to note that there have been instances where things don't stay behind closed doors. In this day and age, people carry a recorder in their pocket. And several years ago, there was a school board executive session where someone recorded the executive session, mailed it to the local newspaper, and then a local newspaper ran with it. And it became a story because it was clear in listening to the recording that the school board had conspired to violate executive session by discussing things about the superintendent search that should be in the public session. And it was done that they did that by talking about how the board president said, well, I had one-on-one telephone conversations with each of you in order to avoid having a quorum. And don't do that. The Sunshine Act isn't very forgiving about getting cute on the law and saying, I'm just going to talk to people one-on-one, and then there's not a quorum. Avoiding public scrutiny, avoiding working around the Sunshine Act, judges tend to see right through that. So this is an extreme example, but know that maybe you think no one's ever going to know about you violating the executive session, but there's ways that the world can find out. Situations that might violate the Sunshine Act. Email chains. You can meeting by email is a violation of the Sunshine Act. So emailing around a quorum of people and saying, what do you think about this? What do you think about that? That is something we've seen judges come down on agencies for. Having a work session that moves to deliberation, even though you did everything right initially, there became a deliberation portion. And at that point, someone needs to step and say, whoa, we're deliberating. We're not going to do that. Executive session, it evolves beyond the scope of the announced topic. Again, it's important to speak up and say, we're going beyond what we announced. Let's stop this discussion. And the one that I just mentioned, having one-on-one deliberations with each member to avoid having a quorum. So again, like I said, the Sunshine Act is pretty firm on these things, that these are not workarounds that are acceptable. Here are some problems that people, again, perhaps tried to get cute on this, but there was a case many years ago, over a decade ago, where I don't know how this happened, if it was by accident or got a tip, but a reporter found out that 2 of the 3 commissioners of a county were having a breakfast together, I think twice a month at a restaurant, and discussing agency business. So because there's only 3 commissioners in this county, 2 of them meet. That's a quorum. And so the reporter just sat at the table near them and heard them discussing all sorts of things and violating the Sunshine Act pretty blatantly. So that's an example. And there was another example of what I mentioned, a private email vote, where the Sunshine Act, or some board members agreed to hire a management consultant through an email vote. That's not in the public. That's not for giving the public a chance to speak or hear about it for the vote. There's also the spirit of the law. This one I don't believe went to the courts, but it was sort of embarrassing. There was a political group that wanted to meet with a bunch of school board members, and the media got a hold of some correspondence from this pack, and said in there to them, remember, no more than 4 Sunshine Law, saying don't send more than 4 of your school board members or else it will be a quorum. That is not something that is perhaps technically violating it, but it is not in the spirit of the law, and your residents may have something to say about that if they think you're trying to avoid what the Sunshine Act is about. So there's a lot on the do's and don'ts of holding a meeting. Now, what happens if there is an alleged violation? You can pursue by individual civil and criminal penalties. There may be fines and fees imposed. And if a decision is found to violate a law, it may be voided. There was a case in Lancaster County where there was I remember when drop boxes for voting by mail was a big to do. They decided to the county council, county commissioners decided to remove the drop box, but they had not put that in the agenda. It was a complete surprise. So initially, they removed the drop box, and then some citizens filed a complaint saying this violates the Sunshine Act because you did not have this on the agenda, so the public didn't know about it, didn't have a chance to speak. And they won. So they put the vote by mail box back in, and then they put it on the agenda and they voted for it the correct way, and then the box was removed. So all of those things can happen, and it is something that is done through the courts. An interesting sort of quirk of the law is a civil complaint must be filed within 30 days of discovery of the perceived violation, not when it occurred, the discovery of the perceived violation. Right. I feel like there are many questions flying in because I've not been monitoring them. I'm not going to try to dig in. Kyle, are there things that you or I should discuss that are coming in?
Maybe the last question or one second to last question, Liz. Can you email items to board members for informational purposes for them to discuss at a meeting?
Can you email items to board members?
I was
that one.
I was in the process of responding, so I
Yeah.
could handle the response if you'd like. The answer is yes, as long as it avoids deliberation. Email chains with all the board members where there's deliberation or official action that is not okay under the Sunshine Act, but the mere provision of information is okay.
Question is asked, can we ask residents to state name and address at public forum to make sure they are residents? I see it happen all the time. So I believe that it is common practice to do that.
Leslie, as to your question, can a school board member participate in a voting meeting via telephone? There is an old court case involving the Milk Marketing Board where the court found that participation via telephone was okay. However, there are certain laws out there, like certain township codes and whatnot, that might impose additional requirements. So that would be a question that needs to be run by a solicitor.
No, I've never heard of a case where it's okay to vote by email.
Uh, I was just going to add, you can't vote by email. Deliberation and official action need to be at the open meeting.
Correct. Well, anyone can go to a meeting, but in speaking can be limited. Anyone here had a Chick-fil-A being proposed where they live? Brenda, Brenda says, I wish. Julie, I'm not sure about exactly if you receive the recording, but it is a public record that can be accessed via the right to know law as long as it still exists. Now, a lot of agencies will delete their recording. Jackson had a question about when the people should be able to speak. I think about it this way. The reason the public should be able to speak is so that everyone, including those people making the vote, have a chance to hear the public's opinion before they vote. So it wouldn't make sense to have a vote and then let the public speak. In terms of the specific order, I don't believe it opines on that, but the board needs to be able to hear the public's opinion on a matter before they vote. Julie, I cannot tell you if you should retain the recordings or not. Some people think it's great civic demonstration to keep the recordings available. And I will say the public gets really confused as to why they can watch 10 million cat videos at any time they want, but a board meeting from last month is not available. That's not something that there's a legal ruling on. Yes, you can make the question about whether or not you can limit the time people speak. You can make reasonable limitations, Margaret, on the time to speak, or else people might be there for 24 hours. Does the member of the public have the right to ask whether they are the subject of an executive session? Kyle, what do you think? I've never heard of that being able to ask. Go ahead.
Yeah, I'm not aware of anything one way or another. In certain situations, it seems like confirming that might be partially destroying the reason for executive session, but that's kind of beyond us.
Sayward asks, can the videos take the place of meeting minutes? They cannot because of what the law says. So yeah, you have to have meeting minutes. We'll stay just for 2 more minutes to see if there's any last minute questions. You guys are good. These questions are great. When advertising a meeting held at public place and via Zoom with the Zoom meeting code ID. I think in terms of Brenda's question is if you have to the Zoom meeting code ID be included in the statement. I think you just have to give them a way to get the Zoom information. I don't think it's specifically said it must have the exact link, which is a bunch of gobbledygook if you're just reading it, or if you can get it a different way. I think you just have to note that the meeting can be observed via Zoom, and here's how you get the link. And the minutes be online only. I'm not sure about that. They have to be available. An executive session be on the agenda every month prior to the start of the regular meeting. As long as you announce the purpose of the executive session and people know what's happening, I think you can have it as often as you'd like. Examples of executive session for personnel. Should we, let's say you have a township manager and you have several candidates you're discussing, well, Susan seems great, but Julie has a lot of great experience that I think is valuable, that kind of discussion. And the opposite, if you're thinking of terminating the township manager, that discussion. But when you go to make the decision, we are going to hire Mary for the position, that vote should be public, or we're going to terminate so-and-so as township manager, that vote would be public. No restrictions to people can record meetings, there's no restrictions. Planting microphones around the room before and after meetings, I've never heard of that. I feel like that would violate something else in terms of space, but you can do it as public space. You can talk about sending flowers to someone without having a public meeting. Like I mentioned, there are things that are not about public agency business. If you see a bunch of people at a girls' basketball game, you're allowed to hang out with them, even if it's a quorum. You can also talk about sending flowers to somebody. All right, we'll do one more question. Sure, about zoning decisions. Easy. I'm just not familiar enough with them to opine on that. Okay, if you had a really important question that you're dying to get answered, feel free to use this email address to send it to us. Thank you for all of your good questions and for hanging in there, and so many of you here. And I hope you have wonderful holidays, and we will see you next year. If not, we will have some trainings throughout the year, and you will be notified when they're occurring. Thank you all.